and provide savings and transitional provisions for continuity, and preserve the validity and enforceability of trusts created under the Trustee Act. The legislation also includes provisions for the keeping of accounts, impartiality, the giving of information, the separation of trust and property, and the preservation of trust property. The bill also provides for the power to trustees from personal liability and indemnification of trustees by beneficiaries, and for the settlement of actions against trustees by alternative dispute resolution. Also on the agenda, an act to amend the Protection of Plant Genetic Resources for Food and Agricultural Act 2018 is to be taken. According to the post-cabinet reports, this seeks to amend the original act to provide for the integration of functions of the management authority in the ministry responsible for agriculture, in keeping with the government's thrust to rationalize public bodies. The objectives and purpose of the bill is to ensure the integration of activities under the Treaty on Plant Genetic Resources for Food and Agriculture into the government's relevant agricultural and development policies and programs. Cooperate with relevant international organizations in establishing and/or strengthening the capabilities of developing countries with respect to sustainable use of plant genetic resources and in promoting and exchanging of plant genetic materials. Manage the Plant Resources Fund and establish and maintain a register of plant genetic resources. An act to amend the Food Storage and Prevention of Infestation Act and for connected matters is also down to be taken. Also on this session's agenda, an act to license and regulate microcredit institutions that provide financing to individuals and micro, small, and medium-sized enterprises, to discourage microcredit institutions from lending money at excessive interest rates and from engaging in predatory lending practices, and for connected matters to be tabled. For your information, the Ministry of Finance and Planning is in the process of preparing a Microcredit Act to create an authority to regulate microfinancing firms. The legislation will allow the entities to be licensed while also providing measures for the protection of consumers. Although there is not a body that regulates the microfinance market, the Money Lending Act sets the framework for how the sector operates. Over the years, the ministry has received complaints regarding the high interest rates being charged by microfinance institutions. It should be noted that the agenda can be adjusted, with items being added, removed, or replaced. If you are planning to attend a session at Gordon House, here are some rules you need to keep in mind. No visitor shall create any act of disorder within the precincts of the House. No visitor shall be admitted to the House without first obtaining an admission card from the office of the clerk. Visitors who remain within the precincts of the House during a suspension of the session are asked to keep silent. It's about time to go over to the proceedings, but first, the answer to our Parliament trivia question. We asked, the Jamaican Constitution came into effect in 1961. Is this true or false? It's false. The truth, according to the Jamaica Information Service, is that Jamaica's constitution was drafted by a bipartisan joint committee of the Jamaican legislature between 1961 and 1962, approved in the United Kingdom and included as the second schedule of the Jamaica Constitution Order in Council 1962 under the West Indies Act 1962. It came into force with the Jamaica Independence Act in 1962 of the UK Parliament, which gave Jamaica political independence. Now on to the parliamentary session.
Now, in addition to that, Mr. Speaker, the Attorney General will move the Terrorism Prevention Act, designated reporting entities, attorneys at law order resolution 2019. And finally, the Minister of Justice will move that a bill entitled An Act to Amend Provisions Relating to the Penalties and Monetary Obligations in various enactments and for connected purposes will be read a second time. Mr. Speaker, those are the matters before this Honourable House today.
Mr. Speaker, if you permit me.
Mr. Philip.
Yes, if you permit me, before we deal with the matters that the House Leader has just put towards you. Just on the matter of the ad hoc way that we deal with the sitting of the House, Mr. Speaker. As when we last sat, we did not expect that the House would have been sitting today, and the notice came to us just over the weekend, over 24 hours ago. Hence why we are having basically so few members sitting in the House today. And just on a matter of principle, because this is not the first time that we are being notified only 24 hours before, while members would have made other arrangements, either in their constituencies or other arrangements. So, you know, just to the House Leader himself, that if we can deal with the matter, yeah, we did adjourn Saturday. Where it matters to deal with the sitting of the House, if there can be ample notice given, because this is something, and we are not objecting to coming to the sitting of the House, but we want to ensure that members are given ample notice so that we can make other arrangements and prepare ourselves for the sitting. But it may be good for you who is an MP that is close by. For those who are not close by, have to make other arrangements. To you, Mr. Speaker, not to the chatterboxes. Thank you, Mr. Speaker.
Mr. Speaker, the one thing I've learned by being in this little job here is that when it comes to the opposition, they learn their lessons quickly and they follow each other religiously. So the young member who is now acting as the opposition House Leader today has been well briefed by the substantial holder of that office. However, the timeline is a little off. Mr. Speaker, when I said that the House will adjourn Saturday, I had no knowledge at that time that a very important matter that affects the financing of this country, because the Minister of Finance has certain obligations that have to be met. And so he informed me that it was very important for the House to convene to deal with the matter today. We are always here. We must always make ourselves available for this Honourable House, because that's ultimately what we are paid to do. That's what we signed on for. We didn't sign on to go to a constituency to go and try to do other work. I know we're 90%.
Order, please.
I know where 90% of your absentees are. I know where they are. But I'm not going to crucify them for trying to climb Mount Everest. That's their business. That's their business. But what I am saying, Mr. Speaker, is that we must always be ready to meet. And the leader of opposition business was informed by me on Saturday morning. I have been here long enough to know that there are times when you convene when you were here, you convened meetings with less than 12 hours notice, yes, which we had to come here and find ourselves here to participate. Always be ready with your bat in hand. Always. So, Mr. Speaker, with that, I invite you to proceed with the matters before us.
Mr. Semudo.
On a point of order, Mr. Speaker.
Mr. Semudo.
On a point of order.
One minute.
Mr. Speaker.
Mr. Semudo. The acting leader of opposition business. Let me just advise this House. I've had only one request of absence from parliamentarians today. One person. Mr. Philip Paulwell. All other members are expected to be here. I understand there may be another one. When the minister is to make a presentation, if his counterpart make a request based on what you are indicating.
Mr.
When
Speaker.
the Speaker is addressing the House, I would be very grateful if members would either listen or sit until he's finished. Thank you very much. And so, Mr. Philip, if the Minister of Finance is going to make a presentation and his counterpart is uncomfortable because of things, he would have some consultation and then we could make some decision on that. Madam, you wish to speak?
Yes, Mr. Speaker. I would wish to You can hear me now, Mr. Speaker? But I can't keep bending like this, sir. On a point of order, Mr. Speaker, I wanted to understand whether or not the leader of government business meant what he said, that we were not here to and not go to our constituencies. He's somebody I have a tremendous amount of respect for. The people have sent us. Mr. Speaker, I feel very uncomfortable. I feel very uncomfortable doing this. The point of order, Mr. Speaker, is that we are elected by our constituencies to come here.
Not for Tuesdays.
And any day that we find that we have to represent. So all I'm asking the leader to do, because he's somebody that I know that has a tremendous amount of respect for his constituency, whether or not he can just clarify that statement so that it does not sit in the Hansard the way he said it.
About Tuesdays. You can't president on Tuesday. That's what he's saying.
Mr. Semudo.
Mr. Speaker, Mr. Speaker, I don't. She doesn't vote for me, but she resides in my constituency. So I'm always mindful of that. Yes, because at some stage I expect her to vote for me. So, Mr. Speaker, the whole idea is that every Tuesday, Wednesday, and Thursday, we should make ourselves flexible enough to respond, because things arise, and we are in a dynamic process here now. Things arise that are not anticipated when we adjourn. In this case, a very important, as the Minister of Finance, I hope the Minister of Finance will explain the level of urgency that attends this particular issue. But I could not invite you, in all fairness, Mr. Speaker. I would never invite the members of this honorable House to come to the House to have only one matter tabled and go home. So what happens is that I usually try to involve the House in other matters that are outstanding. Yeah. And that is why we are taking matters that are carrying over from last parliamentary year. And so the Attorney General will be dealing with the matter, the Minister of Justice will be dealing with the matter, and Mind Sharp, I might, if it's a member from Southern Manchester was here, I would invite him to continue the debate that he started that was so interesting about bauxite mining in various constituencies. So that is the basis on which I made my comments. Not that you must not go to your constituencies on Tuesdays, Wednesdays, and Thursdays.
Mr. Speaker, just to put this in the correct context, as I see it anyway, I think why we on this side are somewhat upset by the way this has been handled is that last week the House sat for an extraordinary piece of legislation. We understood the extraordinary nature of it. We came, it was debated. At the end of those proceedings, the House was adjourned for a date to be fixed. So we are in the budget period when conventionally the House does not meet. A notice was sent by Parliament towards the end of last week as to what would be taking place in Parliament this week. It had 2 committee meetings on it. So many people on this side ordered their affairs accordingly because the expectation is that the House wouldn't sit. What we've been called here today to see or to have done is the tabling of a bill, the tabling of some regulations, and then the House leader said, in order to make it appear that we're not wasting time, some old things that are not urgent are being brought onto the agenda to be dealt with today. And I think that is a chaka-chaka way of handling the agenda of the House and how we conduct our affairs. I mean, we're all big people, have a lot to do. And, there was no reason if we were going to sit this week, Tuesday, why it wasn't adjourned to today. And then everybody would know what it was. That wasn't done. And hence, the level of discomfort on our side. But we're here. Some of us who could make it are here. So let's get on with the important business of the day.
But I couldn't let that stand, Mr. Speaker, because... Now, hold on. Let me make it very clear to you. Your comments are not excused because of your lack of experience in this honorable House. They are not excused. Because the fact of the matter is, when the Minister of Finance has an important matter to take, it is the obligation of the House leader to ensure that his best efforts are used to convene a meeting of this Parliament, without regard for whether or not you consider it a waste of time or not, or an impression being given. It's not an impression. This is the business of the people of Jamaica for which you are employed and are expected to be here.
Mr. Speaker,
Minister, let me make a comment. The Minister is going to make his presentation. If the alternate, after listening, requires certain information that he doesn't have, he can then at that stage state to the House and seek that he make a presentation. So, Minister of Finance, you're asked to proceed. And then announcements.
Laid on the table of the House today are the following: Minister Paper number 11 and Minister Paper number 12 entitled Cabinet Agenda Issues, dated December 3, 2018 and December 10, 2018 respectively. Annual Report of the Jamaica Business Development Corporation for the year 2016-2017. Appropriation Account for the Office of the Public Defender for 2014-2015. The Auditor General's Department Performance Audit Report, Management of the Special Early Retirement Program, SERP. Auditor General's Department Examination Report on the examination of the components of the Fiscal Policy Paper which was laid before the Houses of Parliament on February 14, 2019. The following is a message from the President of the Senate to the Honorable House of Representatives. I have the honor to advise the Honorable House of Representatives that on the 22nd day of February 2019, a bill entitled An Act to Provide for the Compulsory Acquisition of the Shares Held in Petrojam Limited by persons other than the Petroleum Corporation of Jamaica and for connected matters was passed in the Senate without amendment. Signed, Thomas Tavares Vinson, QC, CDJP, President of the Senate.
Sorry. Reports from committees.
Mr. Speaker. Mr. Speaker, before I move the motion, I just wanted a few comments since the House Leader referred to one of the reasons that was given. Mr. Speaker, the government of Jamaica has an economic reform program under which we have been performing at an excellent level. Through that economic reform program, Jamaica's economic prospects have improved dramatically and the quality of life of Jamaicans has improved significantly. Opportunity has been spread far and wide across Jamaica, and indeed unemployment is at a 57-year low, i.e. we've never had employment below these levels. Mr. Speaker, this government intends to put as much effort behind our economic reform program as we did at the worst times of our journey. And the government of Jamaica has a commitment to have tabled in this Honourable House the Microcredit Act in the month of February, today being the last Tuesday in February. Mr. Speaker, the process to get a bill here involves the work and effort of many Jamaicans in the Attorney General's chambers, in the Office of Parliamentary Counsel, in the Ministry of Finance, in the Bank of Jamaica, and various in the printing office, and various stakeholders across society. All of those individuals, Mr. Speaker, would have worked day and night, overtime, to put us in a position when this bill could be tabled, and indeed could be tabled at this time. We owe it to them, the work that they have done. We call upon them to work after business hours. We call upon them to work on weekends as necessary. We call upon them to put in effort to make sure that we can meet our commitments. Right. All it requires for us to meet the commitment is for this Honourable House to convene on a Tuesday. Convention or no convention is the least that we can do to honour the work and honour the commitment of our fellow Jamaicans who work in the public sector. And that is the principle on which we are doing it today and tabling it today, Mr. Speaker.
On a point of order.
Mr. Speaker, on that note.
On a point of order.
On that note, Mr. Speaker.
On a point of order.
Minister, could you...
I'm waiting to be addressed by the Speaker.
She's talking on a point of order. State your point.
The first thing is that I want to get permission to speak from a seat other than my own, and then permission for the point of order.
That's not the point.
I didn't know you were in the Speaker's chair. I'm waiting on the Speaker. That's you. He hasn't given permission yet. You did? Thank you, Mr. Speaker. The Minister just said that all that is required from us to get the job done is to be here. I want to say that that is absolutely not true. It requires more than our presence. It requires our ability to review and make meaningful contributions.
Mr. Speaker, when a member rises on a point of order, it has to be something whereby this person on his feet breached the standing orders. That is where point of order. So if a member rises, it ought to be on an explanation to ask for clarification, but not a point of order. Point of order is based on the standing order. And when you raise a point of order, Mr. Speaker, when any of us rise on point of order, we have to state what section of the standing order we are rising on to talk about point of order. That is all the point of order.
Mr. Speaker, in following up on the members' comments, I wanted to ask, by way of the point of explanation out of what you've said.
But I'm not finished.
Is the Microcredit Act, the bill entitled the Microcredit Act, is it a structural benchmark under the program? Because that was never communicated.
So, Mr. Speaker, under our economic reform program, we have several commitments. And some of those commitments are what the member asked, a structural benchmark. This is not a structural benchmark, but it is a commitment. And not only is it a commitment, Mr. Speaker, I don't know about the other side, but this government is concerned about access to finance. This government wants all Jamaicans to have access to finance. The microcredit bill, Mr. Speaker, deals with access to finance for those among us who depend on microcredit institutions for financing. Low-income households and informally operated MSMEs. The Microcredit Act, Mr. Speaker, seeks to bring regulation to that sector to ensure that Jamaicans are not subject to predatory lending practices, Jamaicans are not subject to excessive interest rates, and that Jamaicans are not subject to the abuse on the part of unregulated microcredit institutions. We believe this to be important, Mr. Speaker, and we don't believe that this is something for us to be arguing about to facilitate the tabling of this bill so it can be taken and quickly passed. Mr. Speaker, this will give greater transparency to microcredit, and it is a shame that the opposition raised objection to the tabling of this bill. Mr. Speaker, under notice of motion given orally, I beg to give notice that at the next meeting of the House, I will move to introduce and have read a first time a bill shortly entitled the Microcredit Act 2019.
Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sittings of the House. Motions for leave to introduce bills. Presentation of bills without leave of the House is obtained. Public business. Mr. Semudo.
Yes, Mr. Speaker. I invite you to invite the Minister without portfolio in the Ministry of Economic Growth and Job Creation to take the matter, the Trust Act 2018, and to close that matter.
The House will now resolve itself into a committee of the whole House to consider the bills clause by clause. I put clause 1. Those in favor? Those against? The ayes have it. I put clause 2. Those in favor? Those against? The ayes have it. Members, if I'm not hearing any reply, I have a difficulty to proceed. So I'm going to put part 1. Those in favor?
Mr. Chairman.
Those against?
Mr. Chairman.
Ayes have it.
Mr. Chairman.
Mr.
Chairman. Sorry, sir. There is an amendment sheet with some amendments, I believe. I don't have a copy of this. Is not the amendment sheet. I don't have a copy of the amendment sheet, but I want to. This is it. I don't have a copy of the amendment sheet to tell you, but it's fair we may be. Wow. 1 second, sir. It's coming. I'm going to assist the minister with this process. If you could recommit clause 2, please, sir. Could recommit clause 2, please. I've asked for the recommittal of clause 2 so that the minister can move the amendments to clause 2. The bill is.
Mr. Golden, look at the bill and tell me which clause you would like me to recommit.
I would like you to recommit clause 2, please, sir. Clause 2.
Clause 2. There's a request to commit clause 2. Those in favor? Those against? Ayes have it.
Thank you. Mr. Chairman, there are 3 amendments to clause 2. They are stated on the amendment sheet that has been tabled, and I would ask that you put the amendments.
Mr. Speaker.
No, sit down, Chairman, Mr. Chairman.
Mr. Chairman.
Sit down.
Mr. Chairman.
Sit down.
I have.
Sit.
Oh, you don't have to stand up?
No. Not for that.
3 amendments.
Proposal for 3 amendments to clause 2. Insert immediately after the definition of beneficiary, the following. Minister, are you aware of the amendments?
Yes, I must be aware of this table.
Minister, are you aware of the amendments?
Yes, Mr. Speaker, yes.
No, Minister.
Yes, Chairman, yes.
Yeah.
I put the amendment to clause 2. Those in favor? Those against? I put clause 2 as amended. Those in favor? Those against? The ayes have it.
I would ask if you could recommit clause 3. So have we finished with clause 2? No?
Those in favor. I said those in favor.
Mr. Golden.
Yes, Mr.
If
Chairman.
you speak to me and you have the mic on, I'm not going to be able to.
No, I'm sorry. I was relaying a point to the clerk.
There's an amendment to clause 3. There's an amendment to clause 3.
Yes, sir. There's an amendment to clause 3. It's on the amendment sheet, and you might want to put it to the House.
So put the amendment. Yeah. I put the amendment to clause 3. Those in favor? Those against? The ayes have it. I put clause 3 as amended. Those in favor? Those against? The ayes have it.
Mr. Chairman, I believe the Minister wishes to finish the process, so I will hand it back to him.
Mr. Speaker, Mr. Chairman, suggest I put clauses 53 to 50, 53 to 58.
4 to 52.
If I was quite happy to do it, you know.
Members, it's obvious that you're not participating in this. Doctor, you have to be very careful.
Put clause 3 to 35.
I'm going to put clause 3, and I'm going to put from 1, sorry, clause 3 to 35, because there is an amendment in 36. So I put clause 3 to 35.
Clause 4. Clause 4 to 35, Chairman.
Sorry, that should be clause 4. Clause 4 to 35. Members are going to be asked to vote on it. Those in favor? Those against? As of it.
Let me help you. No, I'll do it. So,
36. I put clause 35.
Yes, this is the amendment.
I put clause 36.
There's an amendment to clause 36, Chair. It's on the amendment.
Put the amendment to 36.
Yes.
Those in favor of the amendment? Those against? As of it. I put clause 36 as amended. Those in favor? Those against? As of.
Put 37 to 40, please, Chairman.
I put clauses 37 to 40. Those in favor? Those against? As of it. I put clause 41.
Mr. Chairman, there's an amendment to clause 41. It's set out in the amendment sheet. If you could put the amendment to the House.
I put the amendment to clause 41. Those in favor of the amendment? Those against? As of it. I put clause 41 as amended. Those in favor? Those against? As of it.
2 and 43.
I put clause 42 to 43 as amended. Those in favor? Those against? As of it. I put clause 44.
There's an amendment to clause 44, Chairman.
And there's an amendment?
Yes, there's a
So I put the amendment to clause 44. Those in favor of the amendment? Those opposed? As of it. I put clause 40. Sorry, I put clause 44 as amended. Those in favor? Those against? As of it. An amendment. I put clause 45 to 47. Those in favor? Those against? As of it. I put the amendment.
There's no amendment to those, so if you could just put 48.
I put clause 48.
There's an amendment to clause 48. It is set out in the amendment sheet. If you could put the amendment, please, sir.
I put the amendment to clause 48. Those in favor? Those against? As of it. I put clause 48 as amended. Those in favor? Those against? As of it. I put clause 49 to clause 67. There's an amendment. Those in favor? Those against? As of it. I put clause 68. I put the amendment to clause 68.
There are two amendments to clause 68. Yes.
Those in favor of the amendment? Those are Clause 68 has two amendments. I wish to put both amendments at the same time. Those in favor of the amendments to Clause 68? Those opposed? I put Clause 68 as amended. Those in favor? Those against? As of it. I put Clause 69 to 75. Those in favor? Those against? As of it. I put the amendment to Clause 76.
There's an amendment to Clause 76. He's done that already. Yes, there's an amendment to Clause 76, if you would put it to us, please, sir.
I put the amendment to Clause 76. Those in favor? Those against? As of it. I put Clause 76 as amended. Those in favor? Those against? As of it. But you're now 77.
Yeah, put it in. 77.
Not amended.
Put it. Clause 77.
I put Clause 77. Those in favor? Those against? As of it. I put Clause 78.
There's an amendment
to Clause 78.
Yes. There's an amendment to Clause 78.
Those in favor of the amendment? Those against? As of it. I put Clause 78 as amended. Those in favor? Those against? As of it. I put Clause 79 to Clause 91. Those in favor? Those against? As of it. I put the amendment to Clause 92.
No, there's no amendment. Yes, there is. Oh, that one. Sorry.
There's a deletion.
Yes.
There's an amendment to Clause 92, sir. It's on the amendment sheet, if you could put it.
Yes.
Are we not calling it an amendment?
That's correct.
Yes. It's a substantive change
You
to the
delete
clause.
the word
Yes, it's an amendment.
5 and substitute 7. I put the amendment to Clause 92. Those in favor? Those against? As of it. I put 92 as amended. Those in favor? Those against? As of it. I put Clause 93 to 96. Those in favor? Those against? As of it. I put the title and enacting clause. Those in favor?
I can point out the change.
Minister of Finance. I put the title and enacting clause. Those in favor? Those against? As of it. The question is, I do report the bill as having passed committee stage with 13 amendments. Those in favor? Those against? As of it. I do report the bill as having passed committee stage with 13 amendments. Minister.
Mr. Speaker, I know I said the bill be read a third time.
Minister. Those in favor? Aye, sir. Those against? As of it.
A bill entitled An Act to Make Provision for the Establishment and Administration of Trusts and for Connected Matters read a third time and passed.
Mr. Speaker, I now invite you to ask the Minister of Agriculture, Industry, Commerce, Fisheries, and Connected Matters to close the debate on the Food Storage and Prevention of Infestation Amendment Act 2018.
Thank you, Mr. Speaker.
Minister.
Mr. Speaker, I want to first of all thank the opposition spokesman on agriculture for his comments and his contribution in support of this bill. It is by no means, Mr. Speaker, a controversial bill, because it is the intention of the bill is, and by way of just a brief repetition, that the amendments to the Food Storage and Prevention of Infestation Act will modernize the legislation in keeping with advancement in technologies and other changes. It will ensure a clean and healthy environment for the transportation and storage of food, and most importantly, Mr. Speaker, it will ensure the safety and wholesomeness of food being consumed by the citizens of Jamaica. So in light of the aforementioned and the support expressed by the opposition spokesman on agriculture, I now move for second reading of the bill.
Those in favor? Those against? As of it.
Which one? A bill entitled An Act to Amend the Food Storage and Prevention of Infestation Act, Prevention of Infestation Act, and for connected.
No? Hold on. The House will now resolve itself into a committee of the whole House to consider the bill clause by clause. Any amendment?
Welcome to change the date.
I put clause 1. Those in favor? Those against? As of it. Members, if there are amendments, you should advise the Speaker. I put clause 2. Those in favor? Those against? As of it. I put clause 3. Those in favor? Those against? As of it. I put clause 4. Those in favor? Those against? As of it. I put clause 5. Those in favor? Those against? As of it. I put clause 6. Those in favor? Those against? As of it. I put clause 7. Those in favor? Those against? As of it. I put clause 8. Those in favor? Those against? As of it. I put clause 9. Those in favor? Those against? As of it. I put clause 10. Those in favor? Those against? As of it. I put clause 11. Those in favor? Those against? As of it. I put the schedule. Those in favor? Those against? As of it. I put the title and enacting clause. Those in favor? Those against? Ayes have it. The question is that I do report the bill as having passed committee stage without amendment. Those in favour? Those against? Ayes have it. I do report the bill as having passed committee stage without amendment. Those in favour? Those against? Ayes have it. Minister.
I beg to move, Mr. Speaker, I beg to move for third reading of the bill.
The question is that the bill be read a third time. Those in favour? Those against? Ayes have it.
A bill entitled An Act to Amend the Food Storage and Prevention of Infestation Act and for connected matters read a third time and passed.
Mr. Speaker, we're making good progress here today. Mr. Speaker, I now invite you to once more invite the Minister of Industry, Commerce, Agriculture, Fisheries, and of course all connected matters to read for a second time the bill, an act to amend the Protection of Plant Genetic Resources for Food and Agriculture Act 2018.
Thank you, Mr. Speaker. Honourable members, laid in the House is a bill entitled An Act to Amend the Protection of Plant Genetic Resources for Food and Agriculture Act. The principal act being the Protection of Plant Genetic Resources for Food and Agriculture Act came about as a result of Jamaica's obligations under the International Treaty on Plant Genetic Resources for Food and Agriculture, which aims to guarantee food security through conservation, exchange, and sustainable use of the world's plant genetic resources for food and agriculture. The treaty also establishes a multilateral system to facilitate plant germplasm exchanges and benefit sharing through standard material transfer agreements. The principal act seeks to further the conservation and sustainable use of plant genetic resources and to facilitate access to and use of the plant genetic resources. It also seeks to promote the equitable sharing of benefits of the use of plant genetic resources. The Management Authority was established under the Principal Act as a statutory body to advise the Minister on matters of policy and legal measures that provide for the conservation and sustainable use of plant genetic resources, among other things. However, with a view to increase efficiencies in the public sector, the bill has the effect of removing the body corporate status from the Management Authority, among other things. This bill emanates from the decision of Cabinet number 21/18 dated June 11, 2018, in which approval was given for the following: the integration of certain functions of the Management Authority established under the Protection of Plant Genetic Resources for Food and Agriculture Act 2013 into the ministry responsible for agriculture through its Research and Development Division. The functions to be so integrated are set out in Section 6B to E, 9 and 10 of the Act. The removal of the body corporate status from the Management Authority and the designation of the Research and Development Division of the Ministry responsible for agriculture or any other entity so designated by ministerial order as the Management Authority, and the establishment of a Plant Genetic Resource Advisory Task Force constituting of the members listed in the first schedule of the Act in order to carry out the advisory functions as set out in Section 6A of the Act. So in other words, Mr. Speaker, the management authority will basically become the advisory task force. The decision of Cabinet is aligned to the Government of Jamaica's public sector transformation and modernization program, which is designed to increase the overall effectiveness of public service delivery, reduce cost of government, and to contribute to economic growth. The management authority, which is established under the Act as an entity having a body corporate status, is one of the entities selected under the Government of Jamaica policy on the categorization and rationalization of public bodies for the reintegration and integration of eligible public bodies into the central government. Accordingly, given that the management authority is a non-commercial budget-funded entity, recommendation was made for this entity to be integrated into the ministry responsible for agriculture, which would be achieved by repealing the provision in the Act for a body corporate status of the management authority and to allow a body to operate in order to ensure Jamaica's continued compliance of its obligation under the International Treaty on Plant Genetic Resources for Food and Agriculture, which it ratified in 2006. So it is the advisory body, basically, that would continue to fulfill those obligations, Mr. Speaker, while the management authority itself is subsumed as an independent public body. The bill therefore provides for the integration of certain functions of the management authority into the ministry responsible for agriculture, which will require that the ministry integrate the activities under the International Treaty on Plant Genetic Resources for Food and Agriculture into the government's relevant agricultural and rural development policies and programs, cooperate with relevant international organizations in order to establish or strengthen the capabilities of developing countries with respect to sustainable use of plant genetic resources, and to promote the sharing and exchanging of plant genetic resources. Manage the Plant Resources Fund and establish and maintain a register of plant genetic resources. Mr. Speaker, the bill also seeks to remove the body corporate status from the management authority and designate the Research and Development Division of the Ministry responsible for agriculture as the management authority. So that's an existing R&D division will now take on the management authority function. The bill seeks further to establish an advisory task force which will constitute the members listed in the first schedule of the Act, whose main role will be to advise the Minister on matters of policy and legal measures that provide for the conservation and sustainable use of plant genetic resources and the equitable sharing of the benefits arising out of their use. And I remind you that this advisory function will keep us in line with international standards in relation to the protection of plant genetic resources. Members of the advisory task force would include members, representatives from the ministry responsible for the environment, the National Environment and Planning Agency, and persons qualified in the areas of botany or representatives of farmers and plant breeders. In light of the aforementioned, I ask this Honourable House for its support in passing this bill. What's going on here? Is there, do I need to? Oh, okay, all right. If you need any assistance. So, Mr. Speaker, just a short clause-by-clause review here. Clause 1 provides for the short title of the Act, which is the Protection of the Plant Genetic Resources for Food and Agriculture Amendment Act, 2018. Well, it's now 2019. This clause also stipulates how the bill is to be construed when it is read, in that it is to be read as one with the Protection of Plant Genetic Resources for Food and Agriculture Act, which is the Principal Act. Clause 2 amends Section 2 of the Principal Act by inserting a definition for the advisory task force and by deleting the existing definition of management authority and replacing it with a new definition to mean the Research and Development Division of the Ministry responsible for agriculture or such other entity as is so designated by the Minister by order published in the Gazette. Clause 3, Mr. Speaker, amends the Principal Act by deleting the current Section 4 and replacing it with a new provision dealing with the establishment and the constitution of the Advisory Task Force. Clause 4 simply repeals Section 5 of the Principal Act. Clause 5 amends the current Section 6 of the Principal Act by deleting paragraph A and relettering the remaining paragraphs as paragraphs A to D, and by deleting the words "a funding" and replacing with the words "an approved funding." Clause 6 amends the first schedule of the Principal Act in the heading thereof, as well as in paragraphs 1, 4.1, 5, 6.1, 7 to 12 by deleting the words "management authority" wherever they appear in the aforementioned provisions, and in each case replacing them with the words "advisory task force." Other amendments to the first schedule include as follows. The current marginal note at paragraph 1 is deleted and replaced with "constitution and functions of advisory task force" in paragraph 1 by deleting the words "not less than 11 nor more than 13 members" and replacing same with the words "the head of the Research and Development Division of the Ministry responsible for agriculture, ex officio, and not less than 10 nor more than 12 other members." Also by deleting paragraph A and relettering paragraphs B to 1 as paragraphs A to H, by renumbering paragraph 1 as paragraph 1.1 and inserting a subparagraph 2 which sets out from A to G the matters of policy and legal measures that the Advisory Task Force is charged with the responsibility when advising the Minister. And paragraph 11 is amended by deleting the word "salary." Memorandum of Objects and Reasons. This sets out the rationale for the amendments to the Principal Act on how such amendments will be achieved, Mr. Speaker. So, Mr. Speaker, this simply is, as I said, falls in line with the government's rationalization program, that this management authority will no longer exist as a statutory body, and its main functions have been subsumed back into the Research and Development Division of the Ministry of Agriculture, and that they will now, in conformity with the international standards on the management of plant genetic resources, we now have an advisory body that will give the Minister appropriate advice. Thank you very much, Mr. Speaker.
Dr. First.
Mr. Speaker, again, this bill and amendment to the Principal Act is not controversial. It is in keeping and well aligned with the government's public sector modernization and transformation program. The fact is, Mr. Speaker, that Jamaica would have ratified the International Treaty on Plant Genetic Resources for Food and Agriculture in 2006. And this Principal Act came into being round about 2013. 5 years later, Mr. Speaker, it is, in my opinion, and the opposition's, that the amendments brought here today is in keeping with bringing greater quality, efficiency, modernization to the Principal Act, and will do justice in relation to food security. The idea of removing body corporate status from the management authority that was in the Principal Act is a good one. And the fact that we are now moving to establish a plant genetic Resources Advisory Task Force that will continue to give guidance to the minister in relation to policy and legal matters. Mr. Speaker, one of the things that we must, as a country and in the agriculture sector, begin to accept is that the problem we face, whether with diseases or pests, the problem we face in relation to greater production and productivity is oftentimes as a result of having what we would, in some instance, arcade acts that is not moving in keeping with modern technology or moving in keeping with the international standards that is now demanded across the globe. It is therefore for the opposition the fact that the management authority would be repealed and that the integration of this management authority into the ministry responsible for agriculture and having an active advisory body that has a broad-based membership, and that the opposition strongly supports, having critical stakeholders comprising that advisory body. For us, Mr. Speaker, the clauses put forward by the Minister, 6 clauses making amendments to the Principal Act, is in keeping with our thinking, and therefore, Mr. Speaker, as far as the opposition is concerned, we support these amendments. We support the direction that these amendments would take us in the modernization process. It is therefore for me to support the bill as amended. We believe that after 5 years, any review of a bill is in good keeping. And we also believe, Mr. Speaker, that the bills brought here from the minister today, whether it has to do with storage and infestation or to do with protection of genetic resources for food and agriculture, represents a sector moving in the right direction, a sector being modernized, and a sector that will allow us to respond to the best that exists across the globe. We therefore thank the Minister and his team. We want to thank the persons who crafted these amendments to the bill, and we look forward to quick implementation that will bring greater glory to the agriculture sector. I thank you, Mr. Speaker.
Minister, as you come to close,
Mr. Hilton,
as you come to comment on the bill, I wonder to what extent these amendments will allow for the greater protection of the potential strains in marijuana as we look to improving the protection for different strains of marijuana. I ask a question against the background that when the bill was being we were contemplating amending the legislation affecting to decriminalize marijuana. And in the process of consultation, these are some of the questions that were being posed as to whether and to what extent the existing legislation and framework allow for the appropriate levels of protection to marijuana and to the different strains and genetic strains of marijuana. And I wonder to what extent, not having myself been particularly close to this piece of legislation, the advisory board, for example, the advisory task force, the advisors to the task force, whether it will be so comprised with persons that may assist you and the administration with the knowledge that is necessary to give the protection that we believe is necessary for planned different strains of marijuana. So I just wanted you to address that as you come to close, whether that is in fact a focus of the bill or it is simply something else or more that needs to be done in order to make that possible, the protection of our different strains of marijuana.
Mr. Speaker, let me thank the honourable members for their presentation and in particular the opposition spokesman on agriculture, who has correctly noted that, I mean, the origination of this, the first bill in terms of the establishment of the authority was done some 5 years ago. But in terms of the efficiency and the rationalization program that we have, I'm happy that the opposition is in agreement with the formula that we have put together, which is to set aside the public body and to create an appropriate advisory committee. That, in fact, allows us even more diversity in accessing skills that are out there and to serve in an advisory role. And in that context, I just say to the member who raised the issue of cannabis that certainly would want to be one of the areas that we'll ask the advisory committee to help us to do some further due diligence and exploration into that area, because it is an area of potential concern where there's no question that we have a unique place in that industry. And quite frankly, I don't think it's even being accelerated at a fast enough pace right now. And I think this could very well become another window of opportunity to give us appropriate advice to protect what is unique to us, right? And not to allow it to be contaminated and to be dissipated, in this new global, ganja train, so to speak. So I thank you very much. Thank you for your input. And Mr. Speaker, I beg to move for second reading of the bill.
The question is that the bill be read a second time. Those in favour? Those against? Ayes have it.
A bill entitled An Act to Amend the Protection of Plant Genetic Resources for Food and Agriculture Act, read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause. Members, we're going to put the clauses together since there are no amendments. I put clause 1 to 6. Those in favor? Those against? As of it. I put the title and enacting clause. Those in favor? Those against? As of it. The question is that I do report the bill as have been passed committee stage without amendment. Those in favor? Those against? As of it. I do report the bill as having passed committee stage without amendment. Those in favor? Those against? As of it. Minister.
Mr. Speaker, I beg to move for third reading of the bill.
The question is that the bill be read a third time. Those in favor?
Aye.
Those against? As of it. Clerk.
A bill entitled An Act to Amend the Protection of Plant Genetic Resources for Food and Agriculture Act. Read a third time and passed.
Mr. Speaker, you see we are doing very well today. I now ask that you invite the Attorney General to deal with the matter, the Terrorism Prevention Designated Reporting Entity Attorney at Law Order Resolution 2019.
May it please you, Mr. Speaker. The Terrorism Prevention Designated Reporting Entity Attorneys at Law Order 2019 is before this Honourable House for affirmative resolution pursuant to the power granted to the relevant minister, who is the Minister of Foreign Affairs and Foreign Trade, under Section 15, subsection 2, Clause C, to designate by order, subject to affirmative resolution, an entity as an entity to which the provisions of Section 15 of the Terrorism Prevention Act applies. Mr. Speaker, upon affirmation of the order, any person whose name is entered on the roll of attorneys at law and who carries out any activity involving purchasing or selling real estate, managing money, securities, or other assets, managing bank accounts or saving accounts of any kind, or securities accounts, organizing contributions for the creation, operation, or management of companies, creating, operating, or managing a legal person or legal arrangement, such as a trust or settlement, or purchasing or selling a business entity on behalf of any client, shall become a reporting entity and shall have to determine whether they are in possession or control of property owned or controlled by or on behalf of a listed entity. Mr. Speaker, all such attorneys shall report to the Chief Technical Director of the Financial Investigations Division, established under the Financial Investigation Divisions Act, at least once every 4 calendar months, or in response to a request made to them by the CTD of the FID, either that they are not in possession or control of any property, or that they are in possession or control of such property, and in which case they shall report the number of persons, contracts, or accounts involved and the total value of the property. Mr. Speaker, it is an important obligation being imposed and subject to contributions by other members. I ask that the order be affirmed.
Mr. Golden.
Thank you, Mr. Speaker. Mr. Speaker, the order that is before us for approval is an element within a larger scheme. It is a scheme which encompasses the international fight against terrorism and terrorism financing. And allied to that is the international scheme that fights against money laundering and the proliferation of weapons of mass destruction. So the nations of the world have attempted through international agreements under the auspices of the UN and so on to encourage countries to put in place domestic regimes to deal with these scourges. The order here that we're looking at relates specifically to the legal profession and the role that they are expected to play as a gatekeeper in relation to terrorism and the financing of terrorism. My recollection, and I'd ask the Attorney General if she could confirm this, is that similar orders have already been made in relation to certain other categories of persons who are regarded as being potentially at risk of being agents or facilitators of terrorism financing. There is the accounting profession, there are the gaming industry, there is real estate dealers, and my recollection is that orders were already made for those, but that nothing was done about the attorneys at the time. And I think that is because in relation to the area of money laundering, the orders that were made under the Process of Crime Act to establish a gatekeeping function within the legal profession as facilitators of money laundering, that order was challenged by the legal profession in Jamaica through litigation. And I think that litigation was pending, and in fact the court had ruled on it, and there is a pending appeal. I think the appeal has been heard. I don't know, I'm not sure if I don't believe that the Court of Appeal has yet handed down its ruling on that appeal. But it was in that context that the orders were made under the terrorism legislation for the other at-risk areas, but not for attorneys. We now have the circle being closed, so to speak, in relation to the terrorism piece by this order dealing with the attorneys. And I would just ask if the Attorney General could indicate whether or not my account of the background is accurate, because I'm doing it entirely from memory. And if it's not, if she could just correct it so that the context is adequately recorded in the Hansard notes of these proceedings. And if she could perhaps give an update on where we are in relation to the legal profession and the money laundering piece, the order designating the legal profession as, I think, designated non-financial entities reporting, and yes, that have to monitor clients for source of funds and report anything that may be suspicious about the funding that a client may be bringing to a firm to conduct certain business that might otherwise result in illegal proceeds of crime being laundered into ostensibly legitimate funding. So we support the order. It fills out the remaining gap in the terrorism space in relation to the regime to protect the society against financing of terrorism. But because of the peculiarities of the background of which I've mentioned, I would ask the Attorney General if she could just give us an update on what the situation is in those other areas.
Mr. Hilton.
Mr. Speaker, I am listening intently to the question posed by my colleague to the Attorney General, because I think that would be my concern as a member of the profession, and wanting to play our part in carrying out this surveillance and ensuring that we do, as a profession, that we too assist wherever we can, but mindful of the fact that there are other obligations that we have as attorneys, and wanting to know whether, if the context is correct, as my colleague has said, the appropriateness of the timing of this without the resolution of those matters mentioned by my colleague. So that I'm interested in hearing exactly where we are.
Mr. Speaker, to deal with a simpler issue first, attorneys at law are not the only entities designated for the purposes. Under Section 15 of the Terrorism Prevention Act, foreign companies, in respect of their businesses in Jamaica relating to banking, securities, insurance, investment, advice, or trust, those companies are listed. Financial institutions generally are listed. And in respect of the power granted to the minister to designate by order, subject to affirmative resolution, other entities, the attorneys at law are among others. I do not have the list of all who have already been designated, but included are real estate agents and other practitioners in the business. It is true, Mr. Speaker, that the responsibility being placed on attorneys at law in this respect is part of a bigger scheme of work, and that the designation and the burden being placed on the legal profession has been the subject of litigation before the courts, and a stay was granted by the Court of Appeal in respect of the matters under the Proceeds of Crime Act. The stay is in respect of specific provisions of the Proceeds of Crimes Act. It is also applicable to regulations made under the said act, and the General Legal Counsel of Jamaica anti-money laundering guidance for the legal profession that relate to specific provisions of the Proceeds of Crimes Act. The stay is not in relation to the Terrorism Prevention Act or regulations made thereunder. So this is a separate law. So the stay, as it relates to the amendment to Canon 4, I believe, of the Legal Profession Act, only applies to the amendment in subparagraph 3 of Canon 4, which makes specific reference to the Proceeds of Crimes Act and any regulations made thereunder. Subparagraph 5(4) of the canons that refers to the Terrorism Prevention Act or any regulations made thereunder is not included in the stay. And so that does not impact the tabling of the order here or the affirmation of the order. But, Mr. Speaker, the effect of the order raises the same concerns outlined by the Jamaica Bar Association in the matter on appeal. The stay of the enforcement of matters relating to the proceeds of crime, though not applicable to terrorism prevention, is the same set of issues. It is our considered view, Mr. Speaker, in light of what the order provides for, and I invite members to read, that for the purposes of paragraph 2, the commencement date is the date falling 6 months after the date on which this order is affirmed by resolution pursuant to section 15.2 of the Act. So there is a time lapse between the affirmation and the coming into effect. And noting the context of the matter on appeal, if the matter is not fully resolved by the court at the end of 6 months, it is likely that the bar could challenge the order and seek to get a stay of enforcement of the orders. That really is what we have. But because it is a different law and the stay does not relate to this law, then we can proceed. And we would have to see what concerns are raised. But the government does have an obligation to continue the work and complete the legislative steps. May it so please you, Mr. Speaker. I hope I have answered the concerns raised.
May I just say that the learned Attorney General in our presentation did recognize that the arguments by the Bar Association with respect to the Proceeds of Crime Act are substantially the same kinds of concern that would apply in this case, where it is not necessarily the passage of the Act itself, but the order that is now being tabled and being debated, that it is the coming into effect of the order, suspended as it is for 6 months, that would give rise to the concerns expressed by the Bar Association. And if as she admits that those are substantially the same arguments, then I believe that my question about the appropriateness and its applicability to the bar still arises and would give me, as a member of the profession, some concern as to the timing and the appropriateness of this as it relates to the profession. Because I do think that the issues that are raised are substantial issues, having regard to privileges that are well owned and respected, and what implication that may have for attorney-client privileges and the upholding of said privileges. So I would have some concern, even on the response from the Attorney General, that as it applies to the bar, that we be cautious. This House certainly would take note of the pendency of the Court of Appeals decision, and to make take appropriate cognition of that as we come to vote on this piece of resolution.
Mr. Speaker, just to mention that there is this sits within an international context, and Jamaica is part of the family of nations that has committed itself to trying to address the international nature and cross-border nature of certain financial crimes. And we are assessed by our peers through the Caribbean Financial Action Task Force, which is a sort of regional body doing the work of the worldwide body headed by I think it's the OECD countries. And I know that we have had peer reviews from time to time. I believe Minister Williams is spearheading on behalf of the government Jamaica's efforts to assure our peers that we are meeting the requirements. But I know this issue of these orders and the one that is before the Court of Appeal is certainly something that would have been the subject of some interest amongst the peer review process. And I was wondering if there's anything that could be said by way of updating the House on how we are doing in that peer review process, especially insofar as this issue of these orders and ensuring that these designated sub-industries, so to speak, bringing them within the rubric of the POCA legislations, know your customer, and other procedural requirements. How is that playing out? Are we?
Mr. Gordon.
Yes.
You're finished. You are making another presentation.
It was I was exercising a certain
I
license.
thought you were seeking some.
And not having been stopped, I was proceeded.
The House Leader would say that he would move for the suspension of the standing orders to seek your permission to have the member make the contribution, because the matter is indeed of interest, not only to him as a member of the House, but also in respect of his profession outside of the House. And Mr. Speaker, I too would need to respond. So the rules are not being strictly observed insofar as how we debate this matter. Minister, who has responsibility for, or who had responsibility prior to taking on a new portfolio, may be in a position to provide some of the information requested, and then I will respond further. May it please you.
In response to your question with regards to where we are right now, when I left the Ministry of Finance and the Public Service, I know the group there is preparing their report to be submitted in March to make it to the June plenary for the CFATEP, Caribbean Financial Action Task Force.
I think that the Hunter are having a difficulty in hearing you. You need to give us some more voice in your mic.
Okay. In response to the question.
Oh, yes. Now you're going on.
Okay. In response to the question as to where we are currently, just want to say that the team that has been working on this, that has been meeting every week on it, they're in the process of preparing a report right now to be submitted to the Caribbean Financial Action Task Force by the end of March of this year. And that report is going to be taken at the plenary in June. And in that report, we have to demonstrate that we have made significant progress in terms of the work that we've been doing. This order today is important. That will form part of that report. Because as you're well aware, the last time the country did the mutual evaluation in 2015, there were some deficiencies, some gaps, and those we have to seek to fulfill. We have to be able to demonstrate that our anti-money laundering regime is robust. And it's effective. We have to demonstrate that we have the legislative regime, but also that regime is effective. It's a long process, but one that we have to keep at, because we are, as a country, a part of the global financial network, and we have to do our part to ensure that we are the strongest gatekeeper that we can be in that international system. So that's where we are now.
Specifically, Mr. Speaker, I did. My friend raised a question about the proceedings at CFATC, whether in the risk assessment, the matter of the assertion of attorney-client privilege, or the matter before the Court of Appeal was the particular subject of any concern or discussion?
Okay. We're in the
Attorney General, you
process.
should
The work is being done currently. And I think the Minister of Finance and the Public Service could probably bring a statement to the House to kind of update the House where we are. I believe. I don't know. I don't want to commit him. I know he's not here, and so I don't want to commit him to that. But I know that substantial work is happening.
More pointedly, whether the matter of concerning the appeal or the litigation here in Jamaica by the bar on the issue of the applicability of the orders to lawyers, whether that was a particular concern in those discussions.
Right. So I attended the CFATF plenary last year. I don't recall that came up for discussion at that plenary.
Mr. Speaker, my understanding of the sum total of the concern is to the extent that the litigation before the courts relating to the provisions of the Proceeds of Crime Act is significant to this matter under the Terrorism Prevention Act, whether the relevant minister should have waited the outcome of that matter before proceeding with this designation under the Terrorism Prevention Act. That is my understanding of the concern that is raised. But as the member would have heard, and I know he knows, the obligations are not just national, they are regional and international, and there is a duty on the government in the context of terrorism financing, anti-money laundering, and all of those matters to pay special attention to all complex transactions, unusual large transactions, or unusual patterns of transaction which appear to be inconsistent with normal transactions carried out by customers. And the attorney at law, it is believed, is in a special position to help to discharge that duty. I would say, though, that the issues raised are important constitutional issues. And as Attorney General, I am watching with keen eyes the outcome of the matter. Governments are being called upon to take actions in the context of international cooperation. But for us, with written constitutions, some of these obligations may collide with what is guaranteed under our Constitution. And so the courts will have to make determination, and we will have to be guided by those determinations of the court. So, in short, the minister cannot and should not wait. But as the House, which must affirm, we certainly are right to take note of the developments outside of the House and to proceed with caution. But no harm will be done by affirming the order and then waiting to see what other development takes place after we have acted. I therefore ask, Mr. Speaker, that the order be affirmed.
Mr. Speaker,
Those in favor? Those against?
All right, now, Mr. Speaker, we will take now item 10, name of the Minister of Justice, in respect of a bill entitled An Act to amend the provisions relating to the...
I don't know if you are speaking, but the mic is not carrying it.
Oh, I'm sorry, Mr. Speaker. Yeah. Is that a little better? Yes. An act to amend provisions relating to pensions and monetary obligations in various enactments and for connected purposes, to be now read a second time.
Minister Chuck.
But then I'll ask for suspension immediately after the opening. Mr. Speaker, I'm very pleased to present to the House of Representatives the Law Reform Amendment of Penalties Act 2019, which is aimed at amending a number of acts under the portfolio of the Ministry of Justice in order to increase outdated monetary penalties in those acts to meaningful and effective levels. Mr. Speaker, in 2017, I made a commitment to bring to update the old penalties and laws falling under the Ministry of Justice. It was towards that end the Legal Reform Department undertook a project through which over 800 laws were reviewed. Mr. Speaker, the process is tedious, and great effort was required to ensure that every single outdated penalty was captured. From this review, certain recommendations were made to the responsible ministries for the updating of laws falling under their respective portfolios. The Ministry of Justice, Mr. Speaker, brought a proposal for its portfolio to Cabinet and received approval to proceed with development of the relevant legislation. The bill was prepared and approved by the Legislation Committee and subsequently Cabinet for tabling in this Honourable House. Mr. Speaker, it is only prudent that this government start the updating of legislation with those falling under the Justice portfolio because as part of its mandate, the Justice Ministry has committed to ensuring that Jamaica is a just and law-abiding society with an accessible, efficient, and fair system of justice for all. A fair justice system, Mr. Speaker, requires proper penalties for any infraction. A fair justice system, Mr. Speaker, requires consistency and certainty in penalties. Penalties that are commensurate with the offences and penalties that will help victims to feel that justice has been served. Penalties that will help to restore confidence in the justice system. The criminals, Mr. Speaker, laugh at the law-abiding citizens in this great nation when they break the law and are given a slap on the wrist because the court is constrained on how much they can penalize them. For example, Mr. Speaker, according to Section 52 of the Criminal Justice Administration Act, if a person is convicted of an assault and battery on any officer of the court while at court, or any justice of the peace or police officer while in execution of his duty, such person shall be liable to a fine not exceeding $40. That is 40 Jamaican dollars, Mr. Speaker, or up to 1 year in prison. Even with sentencing guidelines, Mr. Speaker, the courts cannot levy a penalty above what the law prescribes. This is just one of the many ridiculous penalties we have on the books. Mr. Speaker, the updating of penalties is also one of the measures being taken by this government under the justice reform agenda. This is long overdue. In its analysis of the justice system, Mr. Speaker, the 2007 Justice Sector Reform Task Force opined that one of the problems plaguing our justice system was the lack of consistency of the laws and outcome of various legal processes, including, for example, inconsistency in sentencing, which contributes to uncertainty. Therefore, Mr. Speaker, based on the recommendations of the Justice Sector Reform Task Force, the proposed amendments will not only update the penalties, but will also help to ensure consistency in the penal provisions across the laws. For example, Mr. Speaker, under Witnesses' Expenses Act, for the offense of failing to obey a subpoena, summons, or process order which has been lawfully issued by the court for its attendance as a witness, if he or she has no reasonable excuse, a person can now be fined up to $200 or up to 1 month in prison. However, under the Commissions of Inquiry Act, the similar offense attracts a maximum penalty of a fine of up to $1 million. This is just one of the inconsistencies that currently exists in our laws. This legislation, Mr. Speaker, will place us one step closer to realizing goal number 2 of our Vision 2030 National Development Plan, that is, the Jamaican society is secure, cohesive, and just. It is the intention of the government to establish a criminal code through which a supervisory and quantification scheme will be established to create even greater certainty in our penal laws. Until then, Mr. Speaker, we will start where we can by updating the penalties to more meaningful standards. I must say I urge my ministerial colleagues here on this side of the House in this present arrangement to follow my lead and ensure that by the end of the first quarter of 2019-2020 fiscal year, they too will present bills to this House for the updating of penalties in their respective laws. Mr. Speaker, I will now highlight the main features of this bill. Mr. Speaker, Clause 1 speaks of the law, is the law reform entitled, the name of the Act, the Law Reform Amendment of Monetary Penalties Act 2019. Mr. Speaker, Clause 2 deals with a number of laws, and with your permission, I will not go through all of them. Save and except, Mr. Speaker, to highlight a few significant ones, such as the Corruption Prevention Act, Mr. Speaker, Section 33(1), where we are deleting the words 20, which is $20, and substitute, therefore, the words $1 million. So the penalty is moving from $20 to $1 million. And indeed, Mr. Speaker, similarly, from 1 month, instead of $20 or 1 month, $1 million or 1 year. And when we look, Mr. Speaker, at Section 51, we are deleting the words 20 and substituting, therefore, the words $500 and the words 40 and substitute the words $1 million. And similarly, Mr. Speaker, we are moving from $100 to $100,000 or $1 million, consistent with what can be a deterrent effect. It is not that, Mr. Speaker, the judge is going to impose $1 million if it is breached, but it is there up to $1 million or 1 year as a deterrent for people to obey the laws. Up to. So, Mr. Speaker, it is a maximum penalty we are looking at, not a mandatory penalty, but it is intended, Mr. Speaker, in all of these laws that they should be deterrent and that they should, in fact, encourage our citizens to comply with the laws. Having said so, Mr. Speaker, the bill is before the House. I ask members to have a look at it and ensure that if there are any adjustments to be made, we can do so at the committee stage. But legislation committee has looked at them. We want this to be the likely penalty, the likely penalties that will be imposed are up to the figures designated, Mr. Speaker, because we feel that the penalties that now exist are outdated. And whether these penalties being suggested are the right ones, it is a matter for the House. Legislation Committee feels that we should be consistent not only in the Ministry of Justice bills, but in all the bills in the other ministries, and we hope this will set the tone as to the likelihood of what the penalties could be. Moreover, Mr. Speaker, in this bill, we are provided in the last section of this bill, that is section, that is in the bill itself, Mr. Speaker, that in future any adjustment can be made by affirmative resolution. We don't have to go into each resolution. Just by affirmative resolution, the penalties can be updated. With that, Mr. Speaker, I now commend this bill to the House and hope that other members will examine the bill and make any suggestions or modifications as they see fit. I now ask, Mr. Speaker, that the debate be suspended until a later date for other members to make their contributions.
Those in favor? Those against? Ayes have it. House Leader.
Mr. Speaker, it is not intended to do any further business today, but in closing, I'd just like to say how grateful we all are for those who have remained and had a very civil discussion and debate on the matters before us, and we were actually able to get through quite a bit of legislative work. And I am going to ask that we adjourn this Honourable House, but we will be holding Standing Finance Committee on the 4th, Monday and Tuesday at 10 a.m. on Monday and on Tuesday, and hopefully we will get through in time. We have to, because if not, we'll have to go over to Thursday, because Ash Wednesday, Wednesday is a holiday. So Monday and Tuesday will be Standing Finance Committee of the House to examine the budget and conduct that exercise. So with that, Mr. Speaker, I ask you to suspend this Honourable House. Sign it aye for a date to be fixed.
The question is that the House be now adjourned for a date to be fixed. Those in favor? Those against? Ayes have it. Stands adjourned.
for uplifting entertainment that will change you. Join me, Cassandra, on E-Gospel, Fridays at 8:30 p.m. The show is packed with quotes from the man who changed the course of history and music videos from Jamaica and the world. The musical journey is on Fridays at 8:30 p.m. with encore performances Saturdays at 8 p.m. and 2 p.m. on Wednesdays. That's E-Gospel on PBC Jamaica for uplifting entertainment that will change you.
My friends, we're living in the exciting prophesied time of the end. We must prepare for the glorious kingdom to come.
The religious system of the man of sin is in place today, right now, and already has multiple millions in its sway.
We can tell you how to escape the coming tribulation.
You need to know the future.
I would like to see every crime finish in Jamaica, and the children them, oh boy, it would be a happy world for them. Jamaica is very beautiful and nice, you know. There is nowhere like home. This place is paradise, you know. It's just the crime that really keeping us scared. Let's create a safer Jamaica.
A message from the Ministry of National Security.
In Jamaica, there needs to be one law for all. Every member of this society, regardless of profession, finances, or the area you live in.
I have some bad news.
The company didn't get the contract?
The money they paid us for it has gotten out.
Are you serious?
I'm afraid so, and I understand that there are going to be corruption charges.
Minister, please come with us, sir.
Breaking news.